Case is Scariotti versus the estate of Joan Scariotti. Right? So you're both here. Okay, Mr. Hooley, you're up.
May it please the court, my name is John Hooley. I'm here on behalf of the petitioner for the writ of certiorari, Anthony Scariotti. Now, this is really about Joan Scariotti. Joan is Anthony's grandmother, and the estate was opened, and Anthony filed a claim against the estate based on all of this situation. So Miss Scariati is a resident of Naples, Florida. Her grandson, Anthony, lives over in St. Lucie County. The pleadings show that Anthony talked to his grandmother wanted to invest, and she ended up purchasing a property in St. Lucie County in November of 2013. Now, that's important because the pleadings also show that for this acquisition, her grandson gave her $29,500 prior to closing. And that covered the deposit of $25,000, and it covered closing costs. And we've got the closing documents as well. She, according to Anthony, wanted to get a return on her investment, and Anthony proceeded to remodel it, lease it out, gave her an amortization schedule. And the amortization schedule has what Anthony says is her handwriting on it, and we've never had an opportunity to fully prepare that because a motion in limine was filed but not heard. We have witnesses that will verify that she made those notations on the amortization schedule. So this is the situation. He makes these payments. He sends her checks. Some of the checks say mortgage. They refer to the property as the Cape Cod property. And he makes payments over time, and payments don't follow the amortization schedule because he's paying it off more rapidly. He's handling everything. He's got the taxes. He's paying the taxes directly. He's actually getting the property insurance and everything. And so his last check was given to her on May 17, 2017, and it says balance of Cape Cod. She cashes that check. Throughout this, there's never been any allegations that she made a statement that, she wasn't financing the property for Anthony. So he sends her what is purported to be the balance of Cape Cod on May 17th, and she dies on May 30th, 2017, without having an opportunity to deed the property to Anthony. And none of these facts have really been contested. The only contested fact is that it was in her name, and there's no contract because, it's her grandson. She wants some investment income. Nobody talked to a lawyer. So nobody put this down in writing. So we had what I thought was the serious argument, which was the statute of frauds argument. I'm going, sale of a property, nothing in writing, we lose. But then I looked at it a little further, and the real issue is it an executory contract or an executed contract? And the case law is that if it's fully performed by Anthony, it's no longer subject to the statute of frauds defense. So we go to a motion for summary judgment, and the trial judge says, I accept your argument. It's an executed contract. However, you don't have anything in writing to prove the terms of the contract, so I'm granting summary judgment against you. So that's the big issue here. And I think the issue for the appellate court is, do we have an opportunity to allow the trial court to determine what Joan Scariotti really wanted? She doesn't own any other, pardon?
Mr. Hook, let me interrupt you here, because the big issue for me before we even get to that is, how do we have jurisdiction at this point?
Well, I know that that was raised in the brief. They said that the partial summary judgment really takes the property away from Anthony Scariotti. Now, the appellees have said that the respondents have said that, well, since you didn't file a lis pendens against the property, that's the issue. However, the main case, which is Vermont, cites another 4th District Court of Appeals case that doesn't really say that that is a necessary requirement. I think what the court needs to look at is, can the estate sell the property with the partial summary judgment in place? And I submit that they can.
But they could have before also, right?
I don't think, because he had a claim in the estate, and then the claim was changed into an actual complaint. And I believe that the trustee or the personal representative would have to tell the judge that there were some issues. He's got to submit the proposed transfer to the probate court. And I'm sure that Anthony's father, who's one of the beneficiaries, would object to the sale of the property because of the pending case.
But in other real estate matters, a mortgage foreclosure, other things, lis pendens is part of it. That's just part of the routine process that you file if you want to protect that. So why would that argument not have merit here?
Because the claim grew out of the estate claim. So
but he could still make a claim, and it would be for monetary damages or whatever. But if you wanted to protect on that real estate, why would not a lis pendens have given him that right?
I admit that a lis pendens probably should have been filed. Okay, I admit that. But the question that pardon?
I mean, your second count, isn't that basically a request akin to an equitable lien? Is it not? Your second count of your complaint?
Yes, but here's the thing. The lis pendens is to notify anybody taking the property that there's a pending litigation. But the judge in the probate case needs to approve the sale. And the judge isn't going to approve the sale if there's a pending appeal on the partial summary judgment. If there was no appeal on the partial summary judgment, I believe that the probate court could sell. But I think that there's an obligation on the part of the personal representative to fully advise the probate court of the situation. So I submit that the better practice, as pointed out by the respondents, would have been to file a lis pendens. And it appeared to me that since it was involved in the estate, there would be some oversight. So
I have a question with regard to his interest, because you made a statement, take the property away from Mr. Scariotti. Is it your position that as he was paying this, he had some right, and as far as the rental payments, he had some current interest in it? Or was he just managing it for the grandmother?
Yes, because if you look at the amount of money that he's paying, and it's not like he took the rental payments and paid his grandmother. He took the rental payments and paid his grandmother, and he paid her additional monies that weren't being earned by the property. But in addition, he'd fully paid on the property. So
was it more of a partnership? I mean, what is the?
I think it was more of a joint
interest. What was his interest?
I think it was more of a joint venture. She was actually.
So then why did he not file taxes? Why were there not taxes that reflect his interest?
That, these people are not sophisticated people. But here's the thing that I've got to do. Assuming that the partial summary judgment sits, I've got to go in front of a jury and say, we have unjust enrichment. We'd given Joan Scariotti $29,500 in 2013. We'd managed the property, and we paid her all of this money over and above what the property actually brought in. And we paid the expenses, and we handled the renovations, and all of that money, some of that money came out of Anthony's pocket, and nobody ever made a claim to Joan to contribute to any of that money. So I submit that in addition to the Atkins versus Rybovich Boatworks case, 585 Southern 2nd 270, that the issue for the court is not the list pendants. The issue for the court is whether or not granting the partial summary judgment prevents Anthony from ever getting the property. I think that's the substance of the argument. And by the way, I forgot to ask for my 5 minutes, but how am I doing?
Got it. You're at 10 minutes now, so you still have 10 to go. So
Okay.
I'll give you a heads up at 5.
So I look at this as an agreement for deed, more or less. And I think that's what it is. And I just don't think that a partial summary judgment that takes away the property from Anthony when he's been paying on it for more than 4 years and he makes the final payment before his grandmother dies should prevent him from actually obtaining the property. And I think that the court should also look at the entirety of the facts and see, what did Joan really want? What did Joan want in this deal? And I think if you do that, you're going to see that she did this just for Anthony. And Anthony paid her back. And granting the partial summary judgment and taking the property from Anthony does this. We've got to go to the estate and we've got to get back all of the money as unjust enrichment. Meanwhile, Joan has already been paid all this money. So sometime in the future, she's giving it back. Meanwhile, then the property goes into the estate, and 6 years, 2013, 2022, 5 years. No. Gosh. 9 years of appreciation of the property gets put back into the estate, even though that appreciation was primarily obtained through Anthony's efforts. So I'll reserve the
I
right.
understand you're saying that, well, it's because they're unsophisticated. But that's why sophisticated real estate ventures should have some sort of a written agreement where you could record a document. But you're asking us to make a decision because they're just unsophisticated. And that's no way for us to go forward and do this. I'm just not understanding why we shouldn't deny cert here, send it back. And I understand that puts your client in a difficult spot, but isn't that, I mean, the fact that he didn't do any of these things is what boxes him in. It's not us making a decision not to look at him as unsophisticated and giving him a pass.
And Judge Stargell, I'd agree with you 100%. In an arm's length transaction, two unknown people doing this, I'd say, you know, they're nuts. But this is Anthony's grandmother and Anthony. And so it's a different relationship than an arm's length relationship. And I think the court would not be doing justice if they looked at this to interpret it as an arm's length relationship. That's why I say the court should give Anthony an opportunity to demonstrate to, this is a jury trial, by the way, to the jury that Joan wanted him to have the property and he fully paid for the property. And any other decision, denial of the writ will prevent that. And I strongly urge the court to grant the writ.
Okay. Thank you, Mr. Hooley. Mr. Beatty?
Yes, good morning. Scott Beatty on behalf of the respondent. May it please the court. I think the important threshold determination and what I'm going to focus on primarily is the court's jurisdiction in this particular case and whether or not this court has jurisdiction to issue a petition for cert. This court in the order where it said that this proceeding would proceed as a certiorari proceeding as opposed to a appeal, and granted there were a number of confusing orders on it, but this court cited originally when it decided to take jurisdiction to the Vermont Lakes case out of this district. And as I pointed out in the brief, there's a critical distinction, and as the court, the panel this morning has already pointed out, critical distinction is in the Vermont case, in addition to denying the claim for specific performance, the court in an order denying a claim for specific performance, also discharged a notice of lis pendens. And this court in the Vermont case was very clear, and it said, well, we know that the court has jurisdiction to review orders that discharge lis pendens, and this court has treated those akin to, orders that dissolve injunctions. And so the question that the Vermont court was faced with was, if there is a discharge of a lis pendens, which would give us cert jurisdiction, are we also allowed to review other portions of the order? So in other words, discharge and something else. And the court in Vermont said, because we think that that it would allow the parties to alienate the property before final judgment, the Vermont court said, in this particular case, we're going to find that we have jurisdiction to review it. In this case, we don't have point A. We don't have an order discharging lis pendens, so we don't even get to the and rest of order. The position that the petitioner is taking in this case is Vermont says, well, just because it requests specific performance, we're entitled to cert jurisdiction. And that's not what Vermont said. Vermont specifically says we don't, or the prior cases did not address the question of whether having cert jurisdiction over one portion of the order would operate to give this court jurisdiction to review other portions of the same order. And this court, or I'm sorry, the trial court did not issue an order that discharged lis pendens. Now, what we don't know, the other case, the fourth district that's cited in Vermont is the Atkins case, which counsel mentioned. We don't know whether there was an order discharging lis pendens in that case, but there is also an and in that case. And the and in that case was denied a claim for specific performance and quieted title. Well, if you think about what a judgment to quiet title does, it is in essence discharging a lis pendens, because an order quieting title says, defendant or plaintiff, you do not have any right to an interest in the property. And again, that's absent from this case. So the respondent's position is that this court does not have cert jurisdiction simply because the trial court did not enter an order that also discharged a notice of lis pendens. And the notice of lis pendens was never filed in this case. And that issue is dispositive of the jurisdictional question. Moving very, very quickly, should the court disagree and believe that Vermont or Atkins does provide this court jurisdiction to whether or not there was a departure from the essential requirements, I think it's important to keep in mind what the judge's ruling was with respect to this motion for summary judgment, because I think there is a conflation of two issues here. The argument was that there was an oral contract for the disposition of real property, okay, which as counsel mentioned, means that it is subject to the statute of frauds, although there are a number of exceptions to the statute of frauds, including whether or not the contract was fully performed. That wasn't the issue or the basis for the court's entering summary judgment or partial summary judgment in this case. It didn't deal with a violation of the statute of frauds. The reason was, in order for a plaintiff to prove a claim for specific performance, the plaintiff has to prove by more than a preponderance of the evidence what the terms of that oral contract are, or what the terms of the contract are. It's made more difficult in this case by the fact that it's oral, but the court said, you have to be able to explain to me what are the specific terms of the agreement before you get the remedy of specific performance. And the court in her ruling said, what are the terms of the agreement that says if Mr. Scariotti does X, Joan Scariotti does Y? And she said there was no evidence of that that was presented. And that was the basis for the partial summary judgment, was that he was not able to prove what the essential matters of that contract were in order to get specific performance. And Judge Northcutt, you made this distinction as well. The judge did specifically say, you still have potentially an equitable right. You still have equitable claims, and those are counts 2 and 3 of your complaint. But with respect to whether you can prove the terms of a contract, specific definite terms in order to get specific performance, the judge, as a matter of law, said what you've shown and what you've presented does not rise to that level, and that was the basis for it. Unless there are questions, again, I think the jurisdictional issue dooms this proceeding because we don't have both components as found in Vermont or in the Rybovich case. But even if the court should accept jurisdiction or find jurisdiction, there certainly was not a departure from the essential requirements of the law by the trial court. And therefore, this court should either dismiss it if it has no jurisdiction or deny it if it finds there is jurisdiction. Thank you.
Mr. Beatty, Mr. Hooley,
Yes.
you're up.
Your Honor, as Mr. Beatty pointed out, you've got one case where it was a quiet title action. There was no list pendants involved. But I'm looking at the Second District Court's opinion in 2008 under Vermont Lakes. And at 585, it says, however, each of these cases involved orders solely discharging a list pendants. It gives a list of preceding cases. Thus, the courts did not address the question of whether having certiorari jurisdiction over one portion of the order would operate to give this court jurisdiction to review portions of other portions. And then they cite Rybovich, and they say the Fourth District Court found that it had certiorari jurisdiction to review a partial summary judgment that denied a claim by buyer for specific performance of a real estate contract and quieted title to the subject property and the sellers. There's no indication that a list pendants was involved in that case at all. And I submit that it wasn't. But the appellate court, your court, said, you know, if you're taking away the right to the property, you should be entitled to a petition for writ of certiorari. And so there should be jurisdiction. But then the court goes on.
One of the other things, though, that you just read is they had a contract. So for specific performance,
Whether the contract, yeah, but whether it's an oral contract that's been fully performed or it's a written contract, that has no bearing on the writ of certiorari. I mean, you can't just say, well, since it wasn't in writing, but you're saying that since it wasn't a written contract, we can't prove what the terms are, as Mr. Beatty pointed out. But in fact, we've got an amortization schedule with her markings on it, indicating that the terms of the agreement were pay off the $75,000 that I loaned with interest, and the property is yours. It's not a complicated deal, okay? When's the property yours? Well, there's no date, but it's based on the repayment of the amount of money that she put up for the acquisition of the property. But let's go on. You have to go on to read the rest of the second DCA's opinion. The court found that it had certiorari jurisdiction to review the partial summary judgment because the judgment allowed the real property at issue to be freely disposed of prior to plenary review, thus evading an adequate remedy on appeal. Okay, so it's not talking about a list pendants. It's talking about the substance of why certiorari is important. Certiorari is important because we can't unwind the deal. For me as the trial attorney, you know, the equitable remedy, you know, I've got to tell the jury why he paid $29,500. It makes the entire presentation of the case incomprehensible to a normal jury. So then the court goes on, in this case, as in Atkins, the partial summary judgment that denies Vermont Lake specific performance, including the list pendants, results in a situation in which the contract 160 acres could freely be disposed of prior to plenary review. And that's what's happening here. Even though you brought it back to Vermont and the list pendants. The reality is the substance of this isn't the filing of the list pendants. The substance of the writ of certiorari is, does the property go away? And does Anthony Scariotti never, is he prevented from ever presenting his argument to the jury? And I submit to the court that not only is it wrong, not only is it contrary to all of the evidence, it's also contrary to the clear intention of Joan Scariotti. And I submit to the court that the writ should be granted, partial summary judgment should be denied, and we should go forward with the full trial on all points. Thank you.
Mr. Hooley,
Yes.
in order to leave the virtual courtroom, you click the leave button on your Zoom screen.